Thank you. Thanks so much. Hi, everyone. Glad to be here. Thank you for allowing me to crash this party. It's a great event, and what a fantastic project you're undertaking, so important at this time. The role of the judiciary and its role in preserving democracy is essential, more so now than ever. And so the project that you're undertaking strikes me as really extremely timely and necessary, and I'm grateful to you for it. In addition to teaching international law back at Yale Law School, I also teach constitutional law, and I clerked for Justice O'Connor on the U.S. Supreme Court. And so, these issues are near and dear to me, and very much believe that the project you're undertaking is really critical. In a way, I am kind of taking the big picture, that is the role of law more generally in the international legal system. Obviously, this is kind of the bigger picture within which these questions of the role of judiciary and democracy play out, but in a system that is devoid of rule of law on the international level, it's very hard to have effective rule of law on the domestic level as well. So my plan for today is talk a bit about the kind of old world order, kind of look back historically. Here I'm drawing on the work that I did with my co-author Scott Shapiro and the Internationalists, so sort of laying out kind of historical period when international law looked very different, the global legal order looked very different. Then talk a bit about the modern legal order, the kind of post-war legal order that began to form in the 1920s and really now is symbolized by the United Nations Charter. Then, as you sort of previewed a bit, talk about where we might be going. Talk about what might be some backsliding or unraveling of that legal order. We may be on the precipice of a real shift, and a shift away from the modern legal order towards something new, maybe something back closer to what we had under the old world order, and a kind of unraveling of some of the critical legal principles that have given us a more peaceful and prosperous world for the last 80 years. And then a bit of a question about now what? Well, now what do we do? What do we do with all of this? So that's my plan for this evening. All right, so first, the old world order. If you study international law, and I don't know how many of you have studied international law, but if you have, you've heard the name Hugo Grotius. That's this gentleman here. He's sometimes known as the father of international law. And he's known for a theory called just war theory. He's known as the kind of father of or the author of a book called The Law of War and Peace. And many people think that what he meant by just wars was what we would think of as a just war, like a war generally self-defense or maybe for a humanitarian purpose. He thought of it as something very different. He thought of as war as a means of righting wrongs, and basically any kind of legal wrong could be righted through war. So failure to pay debt, interference with trade relations, religious failure to observe the one true religion. These were all lawful reasons for going to war. So he saw war as a way in which states could attain their rights. So it was a much more capacious view of kind of lawful war. I gathered hundreds of war manifestos that states used to issue before they went to war. So this is not just what a scholar said, it's what states actually did. And one of the top reasons that they gave was self-defense. That's still a kind of reason that we hear a lot today, though what they understood to be self-defense was much broader than what we would consider to be lawful self-defense today. But you can see there's a lot of other reasons that they frequently gave that are quite different from what we consider to be sort of a just war today. But in this just war theory, and the theory where basically any kind of legal wrong was a lawful reason for going to war, things like balance of power considerations, protection of trade interests, law of war violations, enforcing treaty obligations, these were all things that were considered perfectly reasonable justifications for going to war. So in the old world order, there was a privilege to use force at its core. And the argument that make in the internationalists, and I want to make here today, is that that core justification, or that core rationale for the system, then drove all these other sub-rules, meant that there had to be rights of conquest, license to kill, neutrality required impartiality, and that gunboat diplomacy was lawful. And I'm going to lay out a bit about why that is the case. So first, if war is legal, then conquest is legal. Here in Europe, you just have to look at maps over the course of time to see, or just go to one of the many museums here to see how many times land changed ownership. Sovereigns were constantly battling over land, and once you occupied the land, it essentially was yours. This is one of the stories we tell in The Internationalist was from the American war against Mexico, Mexican-American War by this lovely gentleman, President Polk, where the US seized significant portion of what was Mexico, now is modern day southwestern United States from Mexico, took the land as repayment for debts that had been owed to Mexico. So Mexico had owed several $1 million to the United States. There had been an arbitral proceeding. Mexico had agreed that it owed several $1 million. It had agreed to a payment plan. It defaulted on the payment plan. And this was the result. Seizure of all this territory as compensation for the money that was owed to the United States, plus the costs of collection. That is the costs of going to war to take that land back. And that was considered normal, acceptable, lawful behavior at the time. Today, it would seem unlawful, reprehensible, horrible, but it was a very different world. If war is legal, gunboat diplomacy is legal. This is a woodcut drawing from when Commodore Perry showed up in the Bay of Edo, demanding that Japan enter into a treaty with the United States or else. Japan had been closed off to trade for close to 200 years at this point, had decided to not engage in international trade and relations with most states. There was very limited trade with China and with the Netherlands. Otherwise, essentially completely closed off from trade. And Commodore Perry showed up because the US was looking for a port in the region and had decided that Japan was going to provide that port, and essentially forced Japan into signing a treaty of friendship on threat of military invasion. That, again, is unlawful today, but was perfectly normal and ordinary practice at the time, because if war is legal, then gunboat diplomacy is legal. If war is legal, then there can't be a crime of aggression. This guy should be familiar here. Kaiser Wilhelm II, Kaiser Wilhelm II they discussed trying him after World War I. He was in the Netherlands, and the Dutch refused to turn him over because they said there's nothing criminal about waging a war of aggression. Wars of aggression are not criminal acts. That was true at the time. There wasn't any kind of criminal act, and so they refused to extradite him. And if war is legal, then states can't favor either side. Woodrow Wilson, who at the time he gave this address, was running for office, running to be reelected, and celebrating the fact he kept the United States out of war, and was calling for Americans to remain neutral, to not be involved in World War I, to remain neutral, in fact, as well in name during these days that are to try men's souls. That means no favoritism to either side in any way, no sanctions against the side that was the unlawful aggressor. You have to just treat both sides completely equally. Okay, so you should be thinking that most of this is fairly unfamiliar because this is not the way the world works today. And so the question is, how did this shift? How did we get a different world order? You know, part of the answer was there were a bunch of activists who were working to try and prevent war from recurring. A lot of people were talking about disarmament as the key, but there was another set of ideas that were percolating at the time. And one of the key figures was this kind of obscure bankruptcy lawyer in Chicago, Salmon Levinson, who started writing about this idea of outlawing war. He had this idea that we shouldn't have laws of war, that is laws regulating war, sort of laws that would entail sort of how war could be fought, but we should have laws against war, just as we don't have laws of murder, but laws against them. So his thought was, let's just outlaw war. And it's an outrageous idea in a way. The idea that you use law to prevent war is kind of a crazy thought. But it was a really powerful one. And there were many people who thought this was kind of an insane project, but there were enough people who ended up believing that this was the way to prevent global war from happening again. And it led to the Kellogg-Briand Pact of 1928, sometimes known as the Pact of Paris, that outlawed war, where states signed, and at the time was the most ratified treaty in the world. States agreed to renounce war as a tool of national policy in this agreement. Now, the problem was that they hadn't fully thought through the entire system. They hadn't realized that the privilege to use force was at the core of the international system, and that all these rules kind of followed from it. When they took the core and flipped it on its head from a permission to use force to a prohibition on force, all the other rules had to flip on their head as well. But they hadn't really thought that through. They hadn't sort of sorted out how that was going to happen. They hadn't worked out the system more fully. And as a result, it took several years and another world war before they figured out how to write the rules so that the system made sense. The first step in that direction was the response to Japan's invasion of Manchuria. So in 1931, Japan invaded Manchuria on claiming cooked up charges that Chinese brigands had set a charge on the South Manchuria Railway, which was Japanese owned and run, that ran through Manchuria. Turned out later that it was some low-level Japanese troops that had actually set the charge on their own railway to give them a justification for going to war. But Japan used it as a justification for basically taking over all of Manchuria. Now, both Japan and China had been at that big signing ceremony. They had signed the Pact of Paris. They had agreed to renounce war as a tool of national policy. So this was a clear violation. But the world had another problem now, which is the main way in which international treaties used to be enforced was through war. But states had all just agreed to renounce war as a tool of national policy. So how do you enforce a treaty against war when you've agreed to renounce the right to war? They hadn't really thought through this question of enforcement. They hadn't created institutions. They hadn't thought through all the rules. They didn't quite know how to respond. It took a while for them to figure out an initial response. So after sort of lots of hemming and hawing and trying to figure out how to respond to this, they decided that they would respond by basically refusing to recognize the conquest of this territory. So this is Stimson, who was Secretary of State at the time, said the American government does not intend to recognize any situation, treaty, or agreement which may be brought about by means contrary to the covenants and obligations of the Pact of Paris, which is another name for the Kellogg-Briand Pact. So he's basically saying, we're not going to recognize this conquest. This is not yours, Japan. We don't recognize that this has been taken over. They tried to set up a puppet state. The U.S. also said we wouldn't recognize that. The League of Nations quickly joined and issued an almost identical statement to the U.S. statement. So for the first time, you had a case where states said, just because you've taken a territory doesn't mean it's yours. So where there was a right of conquest, now there was no right of conquest. Notice that that same note also said that they would not recognize a treaty or agreement brought about by means contrary to the Pact of Paris. So what they're saying there is we're not going to recognize gunboat diplomacy. You might get China to sign a treaty handing over Manchuria, and that's not going to work. We're not going to honor that. We're not going to agree to it. We're not going to treat that as a lawful agreement anymore. Again, from a modern perspective, seems like no big deal, but in a world in which those had been very ordinary and had been made and enforced for decades, centuries, really, that is a massive change, of course, in terms of whether these kinds of treaties are going to be made and enforced. So where there was gunboat diplomacy, now there's no gunboat diplomacy. The next piece of the puzzle is neutrality. What do we do with neutrality? Neutrality used to require complete impartiality. If two sides are at war, you can't favor one side over the other. And that created a bit of a fix during World War II when the U.S. still had not entered the war. Attorney General Robert Jackson is trying to figure out how to justify the proposed Lend-Lease program. which of course very much favored one side over the other, effectively giving away war material to one side that was not being offered to the other side. How do you justify that? That would have been in clear violation of the old neutrality rules. And he basically says, look, the Treaty for Renunciation of War, which is another name for the Pact of Paris, or the Kelly-Brand Pact, fundamentally altered the place of war in international law and has affected a parallel change in the law of neutrality. So that change in the law has shifted neutrality in a fundamental way. So where neutrality used to require impartiality, now it permits partiality, and economic sanctions are permitted. Last piece of the puzzle is Nuremberg and the crime of aggression. I'm sure this is familiar. I actually was just here last week visiting Nuremberg, the courtroom, which if you haven't been there, I recommend it. And if you look at the first count in the Nuremberg indictment, the statement says that these invasions had been specifically planned in advance in violation of the terms of the Kelly-Brand Pact of 1928. Now, this was extremely important for getting the court off the ground, because the big question had come up: why can we charge a crime of aggression when after the last war we tried that and it didn't work? We agreed that that wasn't lawful, that there wasn't anything criminal about waging an aggressive war. What's changed? And the answer as to what's changed is the Kelly-Brand Pact has changed. Germany had signed and ratified the Pact of Paris, as had Japan. These states had agreed to renounce war, and then they had launched an aggressive war in clear violation of those same obligations that they had entered into. And so the decision was made that that was enough of a justification to create the foundation for what would become the Nuremberg trials. Without that, it would have been very hard to justify the creation of the court. So where there had been a license to kill, that is no crime of aggression, now aggression is a crime. Now you might be thinking, okay, we don't talk about the Pact of Paris anymore. So why am I talking about Pact of Paris? The argument is that that is the kind of foundation that then gave rise to and made possible the UN Charter and the fundamental prohibition on the use of force that lies at the core of the UN Charter. The Article 2.4's prohibition on use of force by states against one another is the foundational principle of the modern legal order, and it wouldn't exist without the Pact of Paris and then all the kind of putting into place these various pieces of a new legal system grounded in a prohibition on war, grounded in law, not force. And that means that this is really a foundational and critical principle of the modern legal order. Now, the system has not been perfect, and the rules have not been perfectly observed, and we can point to lots of counterexamples. But the transformation has nonetheless given us a much more peaceful world for the last 8 decades. Great powers have not gone to war against one another. No UN member state has disappeared as a result of conquest. Conquest, which was once very common, is now rare. It's not that it does not happen. We can point to a few examples, but if you look at the numbers, it is much less common than it once was. But that may be about to change. And this is the question that we're faced with right now. So might and makes right. I'm basing the title of this section on a piece that I wrote for Foreign Affairs that they titled Might and Makes Right. If you write an article for a publication, rarely do you get to choose the titles, but they usually come up with pretty good ones. And this is one I did with Scott, which is really revisiting some of the questions of the internationalists and asking, where are we? What's happening? What's happened to the world that we described having been created in the internationalists, this modern legal order founded in this underlying principle of prohibition on use of force, a system that relies on law, not force, that relies on courts, not war, that relies on judges, not soldiers. Where are we now? Of course, there's been Russia's war of aggression against Ukraine, which is arguably the single most significant challenge to the modern legal order since 1945, appears to be on the cusp of the first example of conquest of territory in Europe since 1945, a clear violation of the United Nations Charter by a permanent member of the UN Security Council that also happens to have nuclear weapons. So a major challenge and threat to the international system. It's not the only violation of the Charter, but it's arguably the most significant one. And in law, what matters, though, is not just the violation, but the response. So this violation is meaningful and worrisome, but there has been some pushback. The General Assembly has passed several resolutions pushing back against, declaring that this is unlawful, declaring that Russia needs to withdraw. There's been a massive effort to aid Ukraine, which I don't have to tell you. You all have been in the middle of it and continue to be. The International Criminal Court has indicted Putin and several other Russian officials for violations, for war crimes and crimes against humanity committed in the course of the war. So there has been a response, and yet the war continues. There's a good chance that Ukraine is going to be pressed into an agreement to give up territory in response for peace. That would be an example of both conquest and gunboat diplomacy, which would be a massive backtracking on the accomplishments of the modern legal order. And it's not alone. China has seized rocks, reefs, and islands in the South China Sea and been building military bases on these contested territories in clear violation of international law and in violation of an arbitral decision against it. And now the US administration has been threatening actions that would violate the core principle of the international legal order. And in a way, this is, as an American, the thing that worries me the most. So Trump has said he wants to make Canada the 51st state. He's threatened to use military force to annex Greenland. He said that he wants to retake the Panama Canal. He used unlawful military force against Iranian nuclear facilities, blowing them up in clear violation of the UN Charter, no real justification for that. And in the latest series of events, the strikes on boats, now I think we're at 19 strikes and over 70 people who've been killed in strikes that have no international or domestic law basis. And so, we're talking mostly about international law here, but in addition to the clear international law violations, there's been no effort to get approval from Congress for these strikes. They did report it to Congress under the War Powers Resolution in September. The 60-day clock under the War Powers Resolution has run out, and they haven't done anything to try and get congressional support for what are clearly unlawful military strikes. Okay, so now what? There's a lot we still don't know. So we don't know whether Trump is going to actually carry out any of his threats. In particular, the thing I worry most about right now is the possibility of force on land in Venezuela, and whether the boat strikes are an effort to sort of warm up to something more in Venezuela itself. Will Trump use the threat of force to gain concessions using gunboat diplomacy? There have been some signs of what are at least seem to be gunboat diplomacy adjacent agreements, these minerals agreements with Ukraine, what seems to have been an agreement on immigration policy with Panama. You may have seen those photos of immigrants locked up in a hotel in Panama, people from all over the world who'd been deported from the United States that Panama agreed to take, probably to try and appease Trump. Will the U.S. withdraw support from Ukraine altogether? He's been sort of back and forth on this. Nobody really knows. Will other states start to treat the law as optional too? Will they follow our lead and no longer consider international law as binding? Could it be that we're sort of headed towards a world in which the great powers sort of carve things up? They exercise control within their regions. They dominate and threaten those around them and allow the great powers of the rest of the world to sort of have their way in their regions. Perhaps there's lots of speculation about that. Of course, Europe is trying to step in and fill the gap, but Europe can't, and I think shouldn't try to go it alone. Needs to build a bigger coalition, but to do that, it really has to admit its own failures. I think the difficulty that Europe has in building a coalition with Africa and Asia, countries in Africa and Asia, is the failure to recognize, the colonial past and the history that brings and the kinds of resentments and anger that are generated by it. This leads me to ask, is the prohibition on force collapsing? This is a piece I wrote for Carnegie, laying out some of these same issues and noting that while this is a dangerous moment, it's also a moment for re-envisioning the world order. It's a moment for thinking about what the possibilities might be. If the old system is unraveling and falling apart, that is tragic, but it's also an opportunity, perhaps, to create something new. And so, in addition to trying to hold on to some degree to some of what we've had, I think we also need to be thinking about what opportunities does this shift open up? Because as there have been changes in the world order before, there could be changes in the world order again. And we could go back to the old world order, but we might shift forward to something else, something new. What can be done? These are just a few ideas, but I think the question is really a project for all of us to be thinking about together. Could mid-sized and smaller states join forces to try to reaffirm the prohibition on territorial conquest and use of force without relying entirely on the United States in the way that states have in the past? The fact the US is pulling back creates an opportunity for more states to play a more significant role. And that could be a good thing if they meet that opportunity, if they step into that role. But if no one steps up to play that role, to enforce the prohibition, to work together in support of it, then we will see collapse of that prohibition. States could work with regional or issue-specific coalitions to achieve their shared goals. So we might not be able to get a kind of global order, everybody on the same page, but maybe we could have mini coalitions, multilateral organizations working together. States might create what I've called an outcasting council, capable of coordinating sanctions. One of the roles the United States has played in the past is kind of getting states together to support collective sanctions when they've not been able to do it through the Security Council because of opposition from China or Russia. But states don't need the US to do that. They could do it on their own. And they could create a standing body if they wanted to pool their capacity, their economic might, to inflict a cost on states that violate international law, if they wanted to. But most of all, now more than ever, we need creative new ideas for strengthening, reinforcing, and reforming the international legal order. And no place better than a school focused on thinking about international law, thinking about international politics, thinking about the law, thinking about rule of law, to begin thinking about that project. So with that, I look forward to your questions.